Action Visa Assistance is not a law firm. We do not provide legal advice. This information is for educational purposes only based on past experience with H2 programs, is not to be considered as engaging in rendering legal, immigration, and/or other professional advice. Should you feel you need legal advice, please contact a board-certified attorney or a tax professional.
Hello. My name is Douglas, and on behalf of our staff at Action Visa, I'd like to welcome you to our webinar on compliance for H2B employers. This segment addresses what to do after your workers have completed their appointments and are now on their way to you. First, please keep in mind that there are several regulations that govern and affect the H2B program. The Immigration and Nationality Act provides for the program itself. There are also a few U.S. Department of Homeland Security regulations, as well as regulations for the enforcement of the program rules and the worker protections under the program that both the Office of Foreign Labor Certification and the U.S. Department of Labor Wage and Hour Division can mutually enforce. The temporary labor certificate issued by the Secretary of Labor certifies that you are a qualifying employer with a temporary need, that there is an inadequate supply of locally available labor, and that the hiring of foreign labor will not have an adverse effect on either the wages or the working conditions of U.S. workers who are similarly employed. It's important for employers to remember that by signing and submitting a petition for temporary employment, you have agreed to follow the rules of the program and to provide the assurances that are required in the job order. So, you've applied for temporary workers, you've proven your temporary need, conducted your domestic recruitment, you have your temporary labor certificate, and we've just sent you a very large email and a text message that your workers are on the way. Now what? We call the large mail we send out the wrap-up, as it wraps up or closes the appointments for your workers. This email has important information about what you need to do for the onboarding of your new hires for the season. Whoever handles your human resources should read that email entirely. The email includes all the applicable U.S. Department of Labor wage and hour fact sheets for the rules of the program, links to the current I-9, W-4, and Social Security application forms, withholding and tax information, and it also includes instructions for the reimbursement of travel expenses, including a customizable Excel spreadsheet to help you determine, pay, and track the payment and reimbursement of travel expenses for the workers. It also includes a consulate report with the names and information of the workers who have processed through their appointment and their status, whether approved, denied, or pending. There is a copy of the job order with the terms your workers were hired under. Your workers should have already received a copy of this in Monterey, but make sure you print this out and give a copy to each worker upon their arrival. The email also includes a notice of obligation for the worker to leave after the completion of the contract term. The form is in both Spanish and English. The workers must sign their acknowledgement of understanding, and you should keep a copy of that in their file. There is also an abscondment notice to be filled out and sent to us, Department of Labor, USIS, and DHS if a worker or a corresponding U.S. worker is terminated, leaves without notice, fails to appear, or if the work is completed more than 30 days prior to the expiration of the contract term. It also includes links to the employee rights posters that have to be posted in a common area, easily viewed and accessible to all employees, and it includes recommendations for time cards that you need to show your obligations under the 3-quarter guarantee, as well as that the job is a full-time temporary position. It's important for employers to remember that U.S. corresponding workers also fall under the same worker protections and guarantees that the H-2 workers receive, and this is a common wage violation according to the Department of Labor Wage and Hour Division. Employers will do well to consider both U.S. and H-2B workers simply as workers. There can be no favoritism shown to H-2 or foreign workers. The regulations require that all full-time temporary job opportunities and requirements such as skill and experience, all the wages, benefits, and working conditions must be the same, required of and offered to both U.S. and foreign workers alike. There are two categories of workers that are not included in corresponding employment. The first category includes incumbent permanent full-time workers who have been with the company for at least a year and have worked at least 48 out of the past 52 weeks, who do the same work as the H-2B workers, provided, however, that the terms and working conditions of these workers are not decreased during the period of the job order. And the second category are incumbent employees who are covered by a collective bargaining agreement of individual employment contract that guarantees both 35 hours per week minimum and continued employment at least through the contract. To qualify as corresponding employment, the work has to be done during the period of the job contract. Now, unless the prevailing wage in terms lowers the wages or working conditions of the U.S. workers, corresponding workers must be paid per the terms of the contract. Food for thought on the HR side, even if your corresponding workers are technically exempt, it will not serve to have a happy workplace when your permanent employees find out the new temporary workers are being paid more than they are. When your workers arrive on their first day of work, we recommend that you first provide the workers with a copy of the job order. This is the customer profile from the wrap-up email we sent. Provide the workers with a copy of the obligation to leave and get their signatures on both the Spanish and English pages. Make sure the worker keeps a copy. We also recommend that you make copies of all of their travel documentation, their passports, visas, IDs, and then give them back to the worker immediately. Title 18 U.S. Code of Federal Regulations 1592 Section A strictly prohibits employers, the employer's agents, or their attorneys from knowingly holding, destroying, or from confiscating the worker's passports, visas, or other immigration documents. We also recommend on their first day of work have the employees fill out their forms I-9 and W-4. Help translate if you need to, but make sure the forms are fully filled out and are legible. Ask the employees if they want to use their travel documents for their proof of authorization to work or if they want to use something else. Please remember that as long as the documents being presented are on the list of acceptable documents, you must accept the documents that are being presented by the employee. You cannot discriminate against any of the acceptable documents listed on lists A, B, or C. Make sure everything is completely and correctly filled out, dated, and signed before the workers leave the office. If this is their first time working in the U.S., they will need either a taxpayer ID or a Social Security number. Workers now have the option to apply for a new number while processing through the consulate appointment. If the worker has not already applied, the wrap-up email includes a link to the SS5 form to apply for a new number. While the worker is waiting to receive the new Social Security number, you will have to manually track their pay and deductions until that number has been received and can be entered into the system. After the I-9s and W-4s have been completed, we recommend that you take this first day as new employee orientation. Review the potential hazards in the workplace with them, in addition to the requirement for them to use the personal protective equipment that you're required to provide them. Also, review the rules of the workplace with them so they know what the proper procedures are to show up for work, how to clock in, how to clock out, the procedures to report illnesses, etc. Also, take this time to gather all the worker travel-related receipts, time and travel information for the inbound subsistence reimbursement, which will be due no later than the completion of 50% of the term of the work contract. You should make sure that your payroll company has all the required information printed on each check stub. This needs to include the company name, address, and the federal employer identification number of the employer. A rubber stamp will suffice, but the workers cannot work for anyone else. Their visas, wages, job order terms are all tied to the employer's federal employer ID number. Please remember that you must reimburse the workers for their border crossing fees during their first week on the job. This is currently $6 per person. You have already paid for their visas, their consulate appointments, and the bus transportation from Monterey to you, but must now reimburse them for their border crossing fees. This will be covered in more detail in our webinar for subsistence reimbursement. Please remember to keep all of your records for at least 3 years from the date of your certification or from the date of your withdrawal from the program. That concludes this webinar. Thank you for attending and thank you for your patience.